Today, we're jumping into the pretty wild world of intellectual property. Now, I know it sounds super complex, but really it's all about one simple thing: protecting what's yours. Whether that's a name, a brilliant idea, or get this, even a building. We're going to look at some seriously surprising real-world cases that teach us some powerful lessons about ownership. So let's kick things off with a bit of a riddle. What on earth could a huge movie star, an iconic hotel, and one of the biggest butter brands in the world possibly have in common? I know, it sounds like the beginning of a really weird joke, but trust me, the answer is a huge deal. And there it is. They've all been right at the heart of these landmark legal fights that completely changed the game on what it means to own a brand. Their stories, well, they're basically a masterclass in IP, and we're about to break them all down. Okay, let's start with the basics, right? When you think of a brand, you're probably thinking of a name, maybe a logo. But as you're about to see, the law protects way more than just that. Okay, check this out. Take Amul, the dairy giant we all know. Another company tried to register the name Amulya. Their argument, hey, it's a different word. But the court said, not so fast. The names were so similar, both how they sound and how they look, that it would totally confuse customers. And that's the key lesson here, right? Protection isn't about an exact copy. It's all about stopping confusion in the marketplace. And this quote from the high court just nails it. It perfectly shows you what the legal minds are thinking. Just tacking a few letters onto the end of a famous name doesn't give you a free pass. If it looks like it, sounds like it, or even just feels like it, you're probably stepping on their trademark. So we've got brand names covered, but what about something a little more personal? Something that isn't even a formal name to begin with? Well, let's bring in our movie star and see how this idea builds. This brings us to Bollywood actor Jackie Shroff and his iconic catchphrase, Bhidu. So what happened? People started slapping it on t-shirts and all kinds of merchandise. Shroff took them to court, and he won. The court ruled that the word Bhidu was so deeply connected to his personality, to his public image, that it basically became his personal brand. Anyone using it was just trying to cash in on the reputation he'd spent years building. All right, now that we've got the fundamentals down, let's get into the really mind-bending stuff. These are the cases that totally challenge what we think a person or a company can actually claim as their own exclusive property. So what about your own name, your family name? It feels like the most personal thing in the world, doesn't it? So you can definitely trademark it and stop anyone else from using it, right? Well, it turns out it's not quite that simple. Let's look at two of the biggest names in Indian business. You've got Tata. They have spent more than 150 years and just billions of dollars making that name a singular, globally recognized brand. The courts completely agree. That name is exclusively theirs. But then you have Ambani. Now, it's a famous name for sure, but it's also a more common surname, used by lots of unrelated businesses. Their main brand is Reliance. Because of that, the law says they can't stop other people from using the name Ambani. The lesson here, if you want to own a common name, you have to build an absolute legend around it. Okay, so we've covered brand names, catchphrases, and even surnames. But can you go bigger? I mean, way bigger. Can you actually own the rights to the image of an entire building? Think about it. Out of all the famous buildings in the entire world, how many do you think have successfully trademarked their own image? The number is tiny. It's this. Just 4. That's right, just 4. And one of them is Mumbai's incredible Taj Mahal Palace Hotel. They literally trademarked the building's architectural design. This is so incredibly rare because for this to happen, a building has to be so unique, so famous that its very image acts like a logo. It means you can't just use a photo of the hotel for commercial purposes without getting their permission. The way it looks is itself intellectual property. Wild, right? So far, we've been mostly talking about trademarks. But what happens when we shift to new inventions and, well, the absolute Wild West that is the internet? The challenges there get even crazier, and the legal system is running to keep up. So check out this recent patent case. Someone tried to patent a new invention that was really just a mashup of features from other products that already existed. The court shut it down. And the principle is crystal clear. To get a patent, your invention has to be genuinely new and not obvious as a whole. You can't just stitch together a bunch of old ideas and call it a brand new creation. And then, of course, there's the internet, a place where fake websites and copycat products can pop up and disappear in the blink of an eye. It's a huge headache for brand owners, but a recent court ruling shows that the law is finally starting to catch up.
So here's the problem. Online fakers love to hide. They hide behind the privacy policies of domain companies, they hide behind anonymous bank accounts. But a court ruling just changed the entire game. It said that these service providers, the companies that host the domains, the banks that hold the money, they can't use privacy as an excuse to protect criminals. Now, they are legally required to hand over data to law enforcement to track these people down. Phew. So, after running through all of these landmark cases, what are the absolute must-know points to remember? Let's boil it all down into a simple playbook for protecting what's yours.
Okay, here are the 5 big takeaways. Number 1, be distinct. Close enough is not good enough. 2, be first. Your unique personality, your catchphrase, it has real protectable value. 3, be legendary. If you want to own a common name, you better be ready to build an empire around it. 4, be original. A real invention has to be more than just the sum of its old parts. And finally, number 5, be vigilant. The law is a powerful tool, so use it to make online platforms help you fight the fakes. And that brings us to one last thing to think about. We've seen trademarks on names, on catchphrases, even on buildings. We've seen patents adapt to new tech. It leaves us with this one big, fascinating question for the future. In a world of AI, virtual reality, and digital identities, what's going to be the next completely unexpected thing that we can legally, truly call our